Hello and welcome. Today we are going to take a look at the requirements that you need to apply for U.S. citizenship. This video will discuss the eligibility requirements for citizenship. Do you know if you're ready to apply? Let's find out. In order to apply, you must meet certain legal requirements, and there are 8 general requirements for naturalization. We are going to go through them all. So let's get started with number 1. Age. A naturalization candidate must be at least 18 years of age at the time of filing. Also remember, it is beneficial for parents to naturalize because once they become U.S. citizens, their lawful permanent resident children under age 18 may qualify for automatic citizenship if they are living in the legal and physical custody of the citizen parent. Right? Let's see. Number 2, permanent residence. An applicant must be a lawful permanent resident, or LPR, for at least 5 years before applying for naturalization. The application can be filed 90 days early, so that's after 4 years and 9 months. The date when the applicant became an LPR is found on the permanent resident card or green card. The 5 years is counted from that date, okay? Not necessarily when you arrived, when that date is on your green card. For the spouse of a U.S. citizen, the lawful permanent residency requirement is only 3 years. You can, again, apply 90 days early. That's after 2 years and 9 months. 2 notes. There, the applicant must be married to the same U.S. citizen for those 3 years. And a U.S. citizen's spouse must be a U.S. citizen during the full 3-year period. Can't become naturalized and then that counts. They have to be citizens for that full 3-year period. Okay, let's see here. Number 3, continuous residence. An applicant must have at least 5 years of continuous residence in the U.S. before applying for naturalization. An applicant's residence is his or her principal dwelling place. If the naturalization applicant is the spouse of a U.S. citizen, the continuous residence requirement is only 3 years. Okay, so here's some important notes about the continuous residence. Okay, it involves trips out of the country and how long you've been here. So trips out of the country for 6 months or more may break the continuous residence. For trips of 6 months or more, USCIS will presume that residence is disrupted unless the applicant can prove it was not. To prove residence was not disrupted, the applicant should present evidence of ties to the U.S. during the absence, such as continued employment, full access to a home or apartment, and immediate family members that remained in the U.S. Okay. Trips that lasted 1 year or more, so that was for trips that lasted 6 months or more, but now trips that lasted 1 year or more, if you left the country for a year or more, that will automatically break your continuous residence, and the applicant will have to reestablish residence in order to qualify for naturalization. So long absences from the U.S. may also cause a much more serious problem. That is what's known as abandonment of residence. If USCIS believes an applicant abandoned his or her residence, the applicant may be placed in removal proceedings for an immigration judge to decide if the person is no longer a lawful permanent resident. So be very careful that you haven't broken that continuous residence if you did do a lot of traveling for several months at a time. Okay. Number 4 is physical presence. An applicant must be physically present in the U.S. for at least half of the 5 years before applying for naturalization. So, for example, it's a little confusing. For example, there are actually 1,825 days in 5 years. Okay, so you're going to divide that in half, and that equals 913 days. So the applicant must be physically present in the U.S. for at least 913 days of the last 5 years. Okay, you'll figure that out because you'll have to count up all your trips and how long you have been out of the U.S. Okay, so make sure that you've been here at least half the time in the 5 years. And for the spouse of the U.S. citizen, the physical presence requirement is at least half of the 3 years before applying for naturalization, and that's 548 days. Okay, that is physical presence. So be careful. Frequent trips outside the country could cause a problem for the physical presence requirements. So long trips might break your continuous resident, and frequent trips might break your physical presence. Okay, those are two separate requirements. All right, next up is jurisdiction. Jurisdiction number 5. That means an applicant must have lived in the state or U.S. CIS district for at least 3 months before filing the citizenship application. So if you move states, you have to make sure you're there for 3 months before you file in that state. Okay? All right. Let's see. Number 6, English and civics tests. So you or the applicant must be able to pass a test on reading, writing, speaking, and understanding English unless you qualify for an exemption. Okay, and I'll explain all those in a minute. But remember that you're going to have to pass these tests, so you need to have probably an intermediate level of English. The tests consist of reading a sentence in English, writing a dictation sentence in English, answering questions about the citizenship application. They will go through the whole application, and following the officer's instructions during the interview. When the officer is speaking to you, just making general small talk chit chat, they are testing your English speaking skills. Okay? So you must also be able to pass a test on U.S. history and civics. I have lots of videos on that. The test consists of 10 questions drawn from a list of 100 study questions, and the applicant must answer at least 6 questions correctly to pass, right? And that is an oral test. All right. Here are those test exemptions and special consideration. So we have what's called the 50-20. An applicant who is aged 50 or older and has had his or her green card for 20 years or more qualifies for an automatic English exemption. The applicant will still have to take the history and civics test, but can take the interview and the history civics test in their native language. Most often they bring their own interpreter. Okay, the 55-15, similarly, an applicant that is aged 55 or older and has a green card for 15 years or more can get an automatic English exemption and take the history civics test in his or her native language. The other exemption is called the 65-20. So if the applicant is age 65 or older and has had a green card for 20 years or more, he or she not only qualifies for an English exemption, but can also take an easier history civics test in his or her native language. The test is drawn from a list of 20 easier history civics questions instead of the standard 100 questions, and this is called special consideration. And if you've seen these 100 questions, the special consideration questions are marked with a little asterisk on the list. Okay? And there's also an exemption based on disability. So applicants with certain physical or developmental disabilities or mental impairments that make them unable to learn can apply for a disability-based waiver of the testing requirements. In these cases, the disability waiver application, which is Form N648, must be completed and endorsed by an authorized medical professional. And there is a list, there's a link to find authorized medical professional for this specific exemption. All right, let's go on to number 7. Number 7 could be the hardest one for eligibility because applicants for naturalization must have what's called good moral character. Number 7 is good moral character, or GMC, for 5 years before applying for naturalization, or 3 years for spouses of U.S. citizens. However, the good moral character requirement is very complex and encompasses a wide range of issues, from truthfulness on the citizenship application to paying taxes to criminal behavior. And it doesn't always just go back 5 years. It could go back since you've become a legal permanent resident. Okay, so this one is very tricky here. The law does not specifically define good moral character, but describes classes of individuals who are ineligible to show good moral character because of the commission of certain acts or convictions for certain crimes. Okay, so this is very tricky. Some good moral character issues can make an applicant temporarily ineligible for naturalization, while other issues, even if they happened more than 5 years ago, can make an applicant permanently ineligible and subject to deportation from the U.S. So during the naturalization process, USCIS can actually identify applicants who are deportable and place them in removal proceedings. So I'm going to say this here twice because it is so important. An applicant that has ever been arrested or convicted of a crime needs to consult with an immigration attorney or a BIA accredited representative before applying for naturalization to ensure that it is actually safe to apply. Okay? I'm going to put all those links below to find someone if you need help with this part. Again, an applicant that has ever been arrested or convicted of a crime needs to consult with an immigration attorney or a BIA accredited representative before applying for naturalization to ensure that it is safe to apply. Okay, super important there. All right, let's go to number 8, the attachment to the Constitution. All right, we have here applicants for naturalization must understand and be willing to take an oath of allegiance to the U.S. The oath requires applicants to renounce allegiance to any other countries and promise to support and defend the Constitution of the U.S. Okay? Often during the interview, they'll ask you what this means, this oath. An oath means a promise. An allegiance means to be loyal. So the oath of allegiance is a promise to be loyal to the U.S. Okay? We have 2 exceptions here for the oath. One is applicants who are so severely disabled that they are unable to understand the oath can apply for a disability-based waiver of the oath requirements. Also, applicants whose religion or personal beliefs do not allow them to take an oath, to bear arms, or serve in the military can request a modified oath with these portions of the oath modified or omitted. Okay? All right. I will put links below to let you know where to find local, free, and low-cost citizenship classes, English classes, legal help, immigration lawyers, and accredited Board of Immigration representatives. Okay? Please be careful of immigration scams. Unfortunately, there are a lot of immigration scams out there, and these people will take your money and run. It is important to be careful. Okay, that's it for today. Thank you so much for watching, and please don't forget to subscribe. I will be posting a new step-by-step tutorial series on how to fill out the N400 application. So please stay tuned.